She does have apparently a prison number, and I just confirmed with her, and as you can see by the look on her face, she was unaware of that. She's
unaware of everything apparently. She doesn't know she's on probation, she doesn't know she's
never
going
been
to
in
prison.
But she did say that with that last sentence, she actually never did go to prison. I did confirm with her, she did finish out her time here, so in her mind, she's never been to prison before. I understand, from the court's perspective, obviously there's a difference there, but I'm going to respect
the reason she didn't go to prison was because Judge Collins and then Judge Condon apparently gave her 1, 2, 3, 4, 5, 6 chances on probation before she was finally terminated. So she built up all that credit.
Correct, Your Honor. So, Your Honor, again, I'm going to respectfully ask the court for that. Again, she wants to get her life back in order. She's going to get out, regardless of the sentence this court gives, get out someday, and I hope she's sincere with that, and I hope she's able to do that, Your Honor. Thank you.
Thank you. Ms. Sondmakar, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I just want to apologize, Your Honor. With the probation whole thing, I honest to God, I did not know that I wasn't off. I completed everything. I did my mental health assessment. I did one-on-one counseling. I talked to my probation officer a month before I was to be off, and he didn't tell me to come in. He said everything was fine. Then my phone got shut off, and I was homeless, living in a park for I don't know how long, and I just assumed that I was off. I've been with this guy who's been abusive to me for years, and this last time he was choking me out, and the last time he did, he choked me out so badly that I was unconscious and I had to be revived. So I had this girl pick me up, and she picked me up. She had drugs in the car. I didn't know about the drugs, but I got charged with a straw, and it was mine. The straw was mine. I'm not going to deny that. But then I was told if I didn't plead to it, I was going to be indicted with more charges, which I didn't know what they were. I only assumed that I was going to get charged with all the drugs in the car. So I pleaded out to the straw. Yes, I am a drug addict, and I am grateful to have been put in jail because I've been wanting nothing more to get clean. And I am clean now, and I want to stay clean. I just want to get my kids.
The defense has a difficult balancing act here. Counsel isn't pretending his client has a clean history, because the record would destroy that argument immediately. Instead, he openly acknowledges years of substance problems.
Kids, they're 20 years old. One of them lives with my mother, and she hates it there. And I just want to finish my time so I can get my daughter out of there, get into some type of housing, and get my life back now that I'm away from this guy. I've had no contact with him. I haven't contacted him at all since I've been in jail. So I've been away from him, and that's all that I wanted. And I'm just tired. I'm exhausted. I don't want to do drugs anymore. Honest to God, I don't. I know there's people out there who don't do drugs, and they have a happy life, and that's all that I want. I'm just asking that you please be lenient with the sentence. I've been in jail for 90 days. I know that it's not in this case. I just said that. I know that it's not in this case. But I'm just asking that you please be lenient with the sentence and let me get back to my life, and so I can start over. And that's all that I want. And I'm sorry.
Thank you. Schwartz, anything else?
Nothing further, Your Honor.
1 second, Mr. Lesher, please. Lesher for the State of Ohio.
Thank you, Your Honor. The state is recommending prison. The defendant has a criminal history including 17 misdemeanors. In 2017, she was convicted of attempted tampering with evidence, a felony of the 4th degree in possession of cocaine, a felony of the 5th degree. She was placed on probation. In that case, she violated the terms of her probation numerous times before ultimately being sent to prison. And at the time of this offense, she was on probation in Willoughby Municipal Court and had an active warrant out for her arrest. She has already been through treatment on multiple occasions, including the jail treatment program, as well as NeoCap, and despite those prior efforts at treatment, she has reoffended. So the state is recommending prison. Because she is currently serving a sentence out of Willoughby Muni, she only has 3 days credit. Thank you.
Thank you. Ms. Sabnikar, you do know that we have the ability to see your text messages, right?
Yeah.
Yeah. Joe Evans is all up and down these text messages.
After I found out,
You sat there a moment ago and said you haven't had any contact with him. You cut him off.
I did cut him off.
Okay.
If you read the messages, he hacked my bank account, and I was trying to get back my bank account information because he was stealing all of my money. And I have disconnected him, and I haven't called him.
There's tons of messages here that you sent. Are you sending him?
Not recently.
What's recent?
I don't know. Like I said, the last one you can read, it's talking about him getting in my having stolen all of my money. I was trying to be nice so I could get. He had access to the only money that I had. The only way I could get any money on my books. I have nobody doing anything, and the only way was he had all of my information. So I had to play nice.
Well, I'm saying you sat here and said you haven't had any contact with him. You cut him off.
I did.
And that's not true.
But I did recently. If you look at the last ones, it's telling him, I'm done. I don't care what you say, loser, goodbye.
I'm not going to argue. This court has reviewed the pre-sentence report and investigation, drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here today. All this is considering the purposes and principles of felony sentencing set forth in 2911 of the revised code.
The sentencing picture changes once the prosecutor puts numbers behind the history. 17 misdemeanors, prior felony convictions, repeated probation violations, previous treatment, and an earlier prison outcome give the court something much more concrete than promises about starting over.
He hacked my bank account, Your Honor. He had all my money. What was I supposed to do? I mean, he stole everything that I had. I have had no money on my books the whole time almost because I have no one else. So.
You're talking about how much you love him here in this one message I'm looking at right here.
And when was the date on it?
February 6th.
Okay, and after that, I told him, after my daughter came up and got my property, I'm just trying to explain, you're taking it all out of context. After my daughter came up and got my property and changed my information, I told him to go get fucked and goodbye.
And considering the factors in 2912, factors indicating the conduct is more or less serious. Nothing stands out factually indicating it's more or less serious. As for recidivism factors, almost all of these factors are present. The defendant was on probation at the time she committed this offense. She's got a lengthy criminal history. She has failed before in the past to comply with previously imposed sanctions ordered by court. She's been on probation before in the past. She's violated multiple times. The last time, again, that when she ultimately went to prison, she had 6 opportunities before she was sent to prison. And that's just in that one case. There's multiple violations in a lot of cases. She's previously been sentenced to prison before. There's a drug abuse problem that relates to the offense, and she doesn't want treatment. She prefer to go to prison. In this case, there's no genuine remorse. She actually denies committing the offense, claimed that none of the drugs were hers.
I said the straw was mine, Your Honor.
No factors indicate recidivism is less likely. Under 2913B1, the court again finds the defendant was on probation at the time she committed the offense, is previously sentenced to a prison term. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that on count 1, defendant serve a term in prison of 10 months. She has credit for 3 days. I need to advise you upon your release from prison, you can be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority could send you back to prison as punishment for violating the rules for another 5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. I'm going to order the forfeiture of the contraband and instrumentalities. That covers everything. Mr. Leshy, is there anything I've omitted that needs to be addressed?
No, Your Honor. Thank you.
Mr. Watson.
Nothing further, Your Honor.
Today on State versus Carmen Palladino, file 25 CR 611. We're here today for sentencing. The state of Ohio has been informed that the defendant failed to appear for his pre-sentence investigation with the probation department. Therefore, community control cannot be an option in this case, and we'd ask you to sentence him to an appropriate sentence. Thank you.
Thank you. Ms. Tomaszek, any reason not to go forward with sentencing?
Thank you, Your Honor.
The judge has access to text messages that appear inconsistent with the defendant's claim that she cut off contact with the man she described as abusive. Her explanation is that communication continued because he controlled financial information and she needed access to her money.
Considering Mr. Palladino did not appear for his pre-sentence report, we would just like to make an oral motion to continue the sentencing and allow Mr. Palladino an opportunity to complete the pre-sentence report. Your Honor, part of the reason he didn't appear, Mr. Palladino was in treatment in Alliant Health Group. He left residential treatment, was getting rides from one of his friends. She wasn't able to bring him. He did end up enrolling back into treatment at Legends all the way in Defiance, Ohio, Your Honor. So that's the reason for his absence of the pre-sentence report. So we would just like to ask the court an opportunity to allow Mr. Palladino to complete it.
He let nobody know where he was. I mean, that's not his. He talked to probation a couple times. He never told anything about that.
I understand, Your Honor. He does now have transportation. Joe from Legends is here. They're able to transport him to and from court, to any pre-sentence report appointments, if Your Honor would allow that continuance. Thank you.
Well, this court afforded Mr. Palladino an opportunity to get a pre-sentence report completed. And he was specifically advised at the time we were here that what would happen if he didn't do that. That we weren't going to continue the sentencing hearing and delay it to get an opportunity to get a PSR because it wasn't completed initially because he didn't show up. Now, the initial time he had it set with the probation officer, he contacted them and advised he couldn't make it, didn't have a ride, and was asking her, could we just do it over the phone or do it virtually? And he was advised, no, it's got to be in person. You need to come in, give a urine sample. They then scheduled another date, and he didn't show, and he didn't call, and she never heard any more from him. And today's the first we're hearing from Mr. Palladino. So that motion to continue this hearing is denied. He had that chance. It was given to him. He decided not to do it, and we're going to go forward with sentencing today.
Okay. Thank you, Your Honor.
So is there anything you'd like to say on behalf of your client?
Yes, thank you, Your Honor. We would just like to ask the court today for any leniency in sentencing. Your Honor, and speak with Mr. Palladino. Upon being released from Lake County Jail, he did enroll himself into residential treatment. He was originally at Ethan's Crossing, got a referral to Alliant Health Group. He was there for about 2.5 months, Your Honor. He did complete residential there. He has since moved to Legends because he did move to the west side, so he enrolled himself in a new residential treatment program, Your Honor. I do have a letter from his case manager there. He was admitted to treatment on February 23rd, and he is currently actively involved. He was in the detox level of care, Your Honor, and he is set to start residential for 30 days, and then he was going to continue doing sober living there, IOP, PHP, Your Honor, so he's trying to get any sort of treatment he needs. And Your Honor, as I already reiterated, for him not showing up to probation, he does understand the severity of it. I believe if Mr. Palladino was able to secure a ride, he absolutely would have been there. We have been in contact. I know during his detox period, he did not have access to a phone. I had to try to even coordinate to get in touch with him. I had to speak with his case manager. She was able to set up a date and time for me to speak with him. So, Your Honor, we would just ask for any leniency in sentencing today. Thank you.
Thank you. Mr. Palladino, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, I'm sorry that I didn't make it to my PSI, pre-sentence investigation. I went to the first one. The other one was
The
scheduled.
first one, well, the one after your hearing.
Yeah, the one after my hearing.
Right.
And then I was scheduled to go to another one the day after the Super Bowl. I can't recall the date or whatever, but she rescheduled because she said she wasn't going to make it in. And that's the reason I didn't make it to that one. And I knew of that scheduled pre-sentence investigation way before, and my grandma was able to take me at the time. Well, due to this situation, I wasn't able to make it after that is because of the ride situation. But I was able to make it on that day, but I was rescheduled. So that's the only reason, and I'm trying my best. I'm in treatment. I've been in treatment for quite a while now, besides the month I was out. And then I just enrolled in treatment. I'm doing good. And I'm starting my residential program. It was supposed to be today. And I plan on going to ILPE and try to do better in my life. I'm not doing bad. I like a job and stuff like that. So.
Anything else you'd like to say?
No, that's it.
Ms. Tomazik, anything else on behalf of the defendant?
Nothing further, Your Honor. Thank you.
For the state of Ohio, Mr. Geigerich?
Thank you, Your Honor. We're just going to ask that a prison term be imposed, and just to point out that the defendant has a prior prison term, so even if he had the pre-sentence investigation report, there would be no presumption for probation. Thank you.
The next case presents a different defendant, but a familiar courtroom problem. Opportunity means very little if the court believes you didn't use it. Defense counsel wants more time, so Palladino can complete the pre-sentence investigation, pointing to residential treatment and transportation problems.
Well, this court has considered the particular facts and circumstances of the offense involved as they were related to the court at the time of the plea. I also received the victim impact statement. I've read and considered that. The court did order a pre-sentence investigation at the time of the plea. Our defendant failed to appear for those scheduled hearings, and a pre-sentence report wasn't completed. There was no drug and alcohol evaluation that was ordered because we were advised that wasn't an issue at the time of the plea. Now the defendant's indicating that there's an issue there. That would have been something that we would have explored had we been advised of that at the time of the plea by the defendant. I've considered what's been said here in court by Ms. Tomazik, the defendant, the prosecutor, the recommendations. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911. For the factors in 29-2912, court finds that the conduct involved here is much more than is necessary to commit the offense of telephone or telecommunications harassment. This is just continual. Even after the defendant was on the phone talking with police, he continued doing this. Causing emotional trauma for the victim. Nothing indicates it's less serious than normal. As for recidivism factors, the defendant has an extensive criminal history going back to when he was 15 years old, and then became an adult and criminal conduct continued. He was sent to prison on 2 separate cases. It's one prison term, but it was 2 separate cases that he was sent to prison on. He has failed to comply with previously imposed sanctions ordered by court. He's been on probation before, and in fact, the cases that he went to prison on were cases that he was initially put on probation and given a chance by the judge, multiple chances. I think with Judge Collins here, I'm looking, there's 1, 2, 3, 4, 5 probation violations before you were finally sent to prison. Been looking at a criminal history. You got prior conviction for the telecommunications harassment. You have prior conviction for violating protection orders. And it's just a lengthy history that just continues on and on. Defendant failed to appear for his pre-sentence report. Those are all factors indicating recidivism is more likely. There's no factors indicating it's less likely. As indicated, in order for this court to be able to consider probation as an option, a pre-sentence report has to be completed. I don't have one. Therefore, I don't have the authority to impose community control sanctions. And based on the history and the conduct, the court finds that that wouldn't be appropriate anyway. Imprisonment is consistent with the purposes and principles of sentencing, and the defendant's not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that on count 1, defendant serve a term in prison of 10 months. He has credit for 8 days he's already served. I need to advise you upon your release, you may be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority could send you back to prison as punishment for violating their rules for another 5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control.
Defense counsel now has to rebuild mitigation without the report that could have documented Palladino's circumstances in the normal way. Treatment becomes the centerpiece. Counsel points to residential programs, detox, continuing care plans, and difficulty reaching him while he lacked phone access. That gives the missed appointment a less careless interpretation, but Palladino still has to explain why communication broke down. His statement tries to separate appointments he could attend from the one he says was rescheduled and the later transportation problem. The challenge is that sentencing judges usually look beyond whether there's an explanation and ask whether the defendant took enough responsibility to solve the problem. His current treatment participation helps because it's an actual step, not merely a future promise. Still, the missing investigation remains a serious procedural problem. The defense is essentially asking the judge to weigh demonstrated treatment effort against demonstrated failure to complete a court-required task. The prosecution strips the argument down to one major point. Palladino has already served a prison term, so completing the missing report wouldn't automatically place him in a favorable probation position. Then the judge adds another problem. The court says the substance issue being emphasized now wasn't presented that way at the plea stage, meaning an evaluation that might have explored it was never ordered. That's a major lesson in sentencing strategy. Mitigation works best when important issues are documented early, not introduced after a required investigation falls apart. The judge also has a victim impact statement and the underlying conduct to consider, so treatment isn't the only concern on the table. By this point, the defense has evidence that Palladino is trying to address his life, but the court is evaluating something broader: seriousness, reliability, criminal history, and whether his recent efforts outweigh the pattern already documented before today. The judge's final analysis shows why the missed report was only one piece of a much larger problem. The court views the harassment conduct as more serious because of its persistence and the emotional harm described, then moves directly into recidivism. Palladino's record reaches back to adolescence, includes prior prison cases, previous protection order violations, a prior telecommunications harassment conviction, and repeated failures on probation. That history makes the defense's request for leniency much harder because the court isn't evaluating a first breakdown in judgment. The missing pre-sentence report then closes another door. The judge states community control can't be imposed without it, and adds that the history would make that option inappropriate anyway. The 10-month prison term therefore rests on both procedure and the broader record. The key takeaway is accountability. Treatment progress mattered, but it couldn't erase repeated sanctions, missed requirements, and the seriousness the court found here.